Today I want to talk about something that people really hate to hear, and that is the reasons why you might not be allowed to sue your employer. And we hear people say all the time, I'm going to sue, but it's not always that straightforward. In fact, there are some times when suing your employer simply is not an option. So today I'm going to talk about 9 specific reasons why you might not be able to sue your employer. Before I get into it, I'll ask that if you like my content, that you please hit the like button. And if you've not subscribed, please do so. It goes a really long way in helping me continue to bring content to you like this. Let's get into it. Number 1, if you fail to go to the EEOC first, then you very well might be precluded, probably will be precluded from suing your employer if you're bringing a race, age, gender, disability, religion claim, those protected classes that are covered by Title VII, the EEOC. Under law, you have to file a charge of discrimination with the EEOC first to give them a chance to investigate. And the EEOC is not an agency that you can skip. You can't skip that step. You have to give them a chance to investigate, even if they don't do a good job investigating. They probably won't, to be honest with you, because they are so overloaded. But nonetheless, you still have to go through that step because they have what you need, and that's what we call a notice of right to sue. The EEOC has to give you a notice of right to sue that you will file when you file your lawsuit in court. If you don't have that, then your case is going to be dismissed pretty much as soon as you file it. Number 2, you miss the statute of limitations. Every claim has a deadline, statute of limitations. And employment cases, we've got deadlines on top of deadlines. So you have only a certain amount of time to get down to the EEOC. You can file your charge of discrimination online. But if you miss that deadline, it's pretty much unforgivable. For private employers, pretty much 180 days is how long you have, but there are some exceptions. If you're trying to file a wage and hour claim, then that's not covered by the EEOC. Typically, you're looking at a 2-year statute of limitations. It just depends on what type of claim you're bringing. You have to speak with your lawyer, look that up. The bottom line is, if you miss the deadline, you will not be able to sue. And this is like unforgiving. It's you're not going to say, I got a doctor's note or whatever. You miss the deadline, then no suing for you. And even with the EEOC, once you get your notice of right to sue, you have 90 days to file a lawsuit. You miss that 90-day requirement, guess what? You don't get to file your suit. Number 3, you might not be able to sue your employer if your employer is not covered by Title VII. So Title VII is what the EEOC deals with. Let's just think about it that way. That's your race, age, disability, religious discrimination claims. But that's a federal law that covers only certain employers. So one of the biggest bars to being covered is maybe the employer is too small. You have to have at least 15 employees where you work in order to be covered by Title VII. So if your employer is too small, there are other things too, but that's usually the main barrier to being covered by Title VII. So if your employer is too small, maybe there are state law claims that you can look to as an alternative, but that might very well be a reason that will preclude you from suing your employer for certain claims. Number 4, if you are an independent contractor, you're not going to be able to sue the employer because you're not an employee. Now, if you are an independent contractor who has been misclassified and your argument is that you're actually an employee, that's a different thing. You will have to sue both for establishing that you are an employee and not an independent contractor, in addition to whatever else it is that you are attempting to recover for. So whether it's discrimination or whatever it is, you have to first show that you are an employee. Otherwise, if you're an independent contractor, you're not going to be able to sue under just your typical employment laws. Maybe you have a breach of contract claim in state court or some other avenue to pursue, but that's another reason why you might not be allowed to sue your employer. Number 5, if you signed a release. And that sounds unusual, but if you sign you settled a case with the employer, you can't later come back and sue them. Let me tell you where this happens all the time. Sometimes employees have more than one claim. For example, you might have a personal, maybe a workers' comp claim. You got hurt on the job. And so you go and seek out a workers' comp attorney and you settle that claim. And when you settle that claim and get your check, you sign a release. And that release might say you are giving up any and all claims, whether known or unknown. And that eats into a claim that you might have for employment discrimination. Maybe you had 2 different claims, 2 different lawyers would handle those claims. Employment lawyers are different from workers' comp lawyers. So you have to make sure the 2 lawyers are talking to each other. Otherwise, you might sign away your rights unknowingly. And unfortunately, I've seen it happen a few times. So make sure if you have more than one type of claim, when you see an attorney, you tell them about every claim that you think you might have so you don't find yourself in that situation. And number 6, along those same lines, if you settled your case and later on, maybe soon after you settle, a class action is brought against the employer and it's for the same thing that you dealt with. You don't get to participate in the class action, can't join in later because you already settled your claim. And that does happen. So when you settle your case, usually they'll have language in there about how if a class action comes up, you don't get to participate. So that's yet another reason that would preclude you from suing your employer. Number 7. Now, this one is extremely common. You sign an arbitration agreement. Now, most employers don't even know that they signed it because they do it during the onboarding process when you first start working for an employer. And you're signing all these documents and you don't really know what you signed. You don't know the significance of it. An arbitration agreement says that you agree, if you have problems with your employer, not to sue them in a court of law. You agree instead to go to a private arbitration where a lawyer acts as judge, jury, all of that, just a single lawyer. Sometimes it might be more than one lawyer depending on what you agree to. But in any event, that lawyer sits there and listens to you present your case. The other side, your employer, presents their case, and that lawyer decides whether or not you win and how much you win. So arbitration really sucks for employees, but nonetheless, it's in a lot of agreements, and employees, for the most part, don't even know that they've signed them. Number 8, you fail to go through your employer's internal complaint process first. And this usually applies to say, like federal employees. Maybe you are required to complain internally at their EEOC office before you go to outside EEOC. I think it's the EEO. And then after you complete that process, then you can file a charge of discrimination with the EEOC, then you go to court. So again, another layer for certain employees. If you miss that, then you don't get to sue. So like I said, lots of places and lots of ways for employees to get jammed up, and believe me, it's by design. And finally, number 9, what you are claiming as illegal is not illegal. It's unfair, but not illegal. So in other words, you don't have a claim. You don't have a valid claim. So a lot of people think that favoritism is illegal. On its face, it's not, unless it crosses over and you can show that the favoritism is based on age, race, sex, gender, disability, some protected class. Then it might cross over and become something that you can sue for. A lot of people think that bullying is illegal, but again, it's not on its face, unless the bullying is connected to a protected class. So I tell people always, unfair is not the same thing as illegal. You have to have a claim that is recognized under law. Micromanaging, another thing that's just not illegal. So if your claim is not one that is recognized by law or under law as being illegal, you're not going to be able to sue your employer. So, like I say, people do. I tell people always, people do what they do. So I say you can't sue. Of course, you can sue. It's just that your case will probably be dismissed as soon as you do. So these, I've just given you 9 reasons, very common reasons why you might be precluded from suing. I'm sure there are others. If anybody knows of others, let me know. I always like hearing from you all in the comments. I'll see you next shift.